Okay, I think we are ready to get started. Hello, everyone. Welcome to our second roundtable. Bear with me, I'm admitting people in as I kick us off. We are really excited to have you all with us today. Thank you so much for spending some time to geek out with us about immigration litigation. For those of you who I haven't met before, I'm Adina Applebaum. I'm the program director at CARE Coalition's Immigration Impact Lab. And I'm very honored to be here today with my colleagues, Senior Attorney Evan Bettens and Staff Attorney Amelia Dagan. Welcome. They're going to be presenting for us today. How are you guys doing today? How are you feeling?
Doing great. Yeah, the weather up here in DC has been really, really lovely this week, so I've really been enjoying that.
Fantastic. I got more people rolling in. Awesome. Okay, so today we're going to talk all about the different Nexus standards for asylum and withholding, and a couple things to kick us off. So the monthly immigration litigation roundtable is something we came up with at CARE Coalition's Immigration Impact Lab, which is our impact litigation program at CARE Coalition. We are changing our name soon in June for our 25th anniversary. You'll hear us being referred to as the Amica Center for Immigrant Rights. Amica is Latin for the word friend, and that's how we view our work, walking alongside the people that we help and represent who are facing detention and deportation. We also hope to be in a supporting role for all of you all joining and other colleagues in the space so that we can make good law together. And so that's really what these roundtables are about, is having a space where we can learn about issues together, share strategies. We do want this to be as informal as possible, so feel free to come off mute, interrupt us to ask a question, or put it in the chat and share your experiences. We want to hear about your cases. We had the first roundtable last month, and it was really awesome hearing people talk about their cases, talk about what's worked in local immigration courts. As always, a plug for referring cases. We are always looking for new cases to check out to support you all with through like co-counseling, mentoring, amicus briefing. So if you have a case that you think might be worth sharing, you can always reach out to us at lab@carecoalition.org. Each month we'll continue having the roundtables, at least for the rest of 2024, and sharing resources as well. So after today's training, we'll be providing some model briefing on this topic to support you all. And I do want to make one request to please, if you haven't yet, fill out the poll that I sent over email. I'm going to put in the chat. This poll, it just has 2 questions. It will help us help you more. Basically, what circuits are you practicing in, and what resources would be helpful for us to continue supporting you all. So with that being said, I'm going to pass over to, I believe, Amelia, starting with the agenda.
Yes.
Awesome.
So welcome, everyone. We're really glad that you're here with us today. Again, we are excited to talk about this issue and hear from you guys and see if this is coming up in your cases and how you guys are handling that. So as a bit of an overview of where we're going to go, we're going to briefly run through a little refresher on what differentiates asylum from withholding. And then Evan is going to walk us through some of the legislative history, some of the differences in statutory language between the 2 forms of relief. And then for the bulk of the presentation slides, at least, we will be talking about what the courts have actually done with all of that statutory language, and then we'll be opening it up. And as Adina said, if you have questions along the way, feel free to share them either in the chat or come off mute and let us know that you want to ask a question. So the first thing we're going to run through briefly, as I'm sure many of you are practicing in this every day, this is not a revelatory part of the presentation, but just as a quick overview, the difference between asylum and withholding, there's a lot of overlap in what you prove to get either of these forms of relief. Under asylum, you show either past persecution or a well-founded fear, which the courts have interpreted to mean approximately 10% chance of future persecution. For withholding, you also show either past persecution or, in that case, a heightened standard of clear probability of future persecution, something over 50%. Both of them have what has been commonly referred to as the nexus requirement, showing that the past persecution or future persecution will be on account of a protected ground. same protected grounds that we always know apply to both. The thing that we will be focusing on today in our talk is the difference of what that nexus standard might actually be. The wording for asylum is at least one central reason, the phrase we're all very familiar with. And then for withholding, the statutory language is simply a reason. And then for both, there is an overlap in terms of showing that the authorities are unwilling or unable to protect your client from harm. And I'll turn it over to Evan to walk us through the legislative history.
Great, thank you so much. So yes, starting in 1980 with the passage of the Refugee Act, the basic nexus language for asylum was on account of, that a non-citizen, in order to qualify for asylum, needed to show that they had a well-founded fear of persecution on account of their race, religion, nationality, or membership in a particular social group or political opinion. And that was the language, the statutory language from 1980 until 2005. And in 2005, in response to some, especially the Ninth Circuit's case law, which seemed to be sort of expanding that standard to encompass, for example, like mixed motive cases in a pretty generous way, Congress took it upon itself to kind of tighten things up a little bit. And they passed, as part of the Real ID Act, which made numerous changes to the asylum statute and the withholding statute. They included language in the asylum statute that replaced this on account of language. And the statute now reads that you must show that the persecution, that the protected ground is at least one central reason for the persecution that your client fears. And so that is significantly different than the on account of language. But at the same time, when they were passing the Real ID Act, Congress did not change the nexus language in the withholding statute, and they left it at a reason. So the non-citizen applying for withholding must show that their protected ground, their protected characteristic was or will be a reason for their persecution. And so we have these two differing statutory provisions in the withholding and the asylum context.
Okay, so next we're going to talk about what the courts have actually done with this different statutory language. So as a brief overview of this next section, we will be kind of covering a few buckets. First, we're going to talk about the BIA and what their take on the situation is. And then as we have divided it and labeled it, we are going to cover the good stuff, the bad stuff, and then the gray stuff, the circuits that maybe have not talked about this issue directly. So we'll get started with the BIA and their take on the situation. So they didn't rule on the issue immediately, but in 2010, they issued the precedential case matter of CTL, citations up on the screen if you want to look at it later, and they still cite to this today. This is still good law. The board held that the standards were the same, that one central reason and a reason in all practice and application should be the same across the board. They gave a pretty wide variety of reasons for this holding, some of which are listed on the screen, but it kind of fell into two main categories. The first one was statutory, and the second one was practical. As a matter of statutory practice or statutory reasoning, they said that adopting two different standards would be unharmonious and unsymmetrical. They based this off of the already quite overlapping similarities between asylum and withholding and what you prove for both. And so saying that Congress did not intend to differentiate them that distinctly, and also saying that Congress intended to provide a uniform standard. And that fit with their practical reasoning for it, which was that the BIA said that before the Real ID Act, they were already applying the same nexus standard to all sorts of cases, both asylum and withholding. And so that in their mind, there was no indication that Congress intended to change that. They thought that applying different nexus, higher for asylum and lower for withholding, would make adjudication of these cases more complex and unpredictable, And then as kind of a last-ditch resort, last stopgap reasoning, they said that their interpretation of the Nexus standard represented a reasonable choice left within a gap left open by Congress. And there they did cite to Chevron, which we will be coming back to later in the slides, but is definitely of interest now, given that the Supreme Court seems prepared to, if not totally get rid of Chevron deference, at least severely limit it later this year.
Thank you, Amelia. And I know we're going to cover it, but just to break things up a little bit, get things a little exciting, what do you imagine for post-Chevron world, how this could change?
For me, sorry?
Yeah.
Yeah. I think that it's a little bit difficult to say. I think it will depend on what ends up being in the decision from the Supreme Court, and it will vary by circuit. Some circuits that Evan will cover in just a second have already decided that they did not apply Chevron deference to this case, or have already come up with their own standard. So I don't think anything will change there. And then in the circuits where it's an open matter, though, I think this will be really interesting because it will leave a lot of space for practitioners, hopefully some of the people on the call who have cases that might end up at the petition for review stage. Hopefully that they will be able to make arguments and then let the courts of appeal decide as a first instance, as the first decision makers, instead of having to be bound by the board, who has for the last 14 years already considered this a pretty closed topic of conversation.
Awesome, thank you. And we're going to dig into these circuit court cases now. Here's kind of the overview of where things shake out on this issue to orient yourselves. And next up, we're going to talk about the good stuff with Evan.
Great. So to start with, the Ninth Circuit was the first circuit court to rule directly on this issue of whether the differing statutory language in the withholding and asylum statutes meant that there was actually a different nexus standard following matter of CTL. And the Ninth Circuit declined to follow matter of CTL. It did not find, well, as a first point, it didn't find the legislative history to support the BIA's holding in CTL. It looked at the legislative history and saw that as part of the Real ID Act, Congress was making a lot of changes to both the asylum statute and the withholding statute, and not just on Nexus, but things dealing with credibility and corroboration. And at that time, Congress could have made the change in the withholding statute to also make it one central reason to mirror the asylum statute if it had so chosen, but it did not do that. And from that lack of change in the withholding statute, the Ninth Circuit drew that reasonable inference that Congress meant for these Nexus standards to actually be different. And then the second main reason that the Ninth Circuit relied on was just the plain language of the statute. So at least one central reason, those are different words than a reason. And typically different words are accorded different meanings in statutory interpretation. So the Ninth Circuit held that these were in fact different standards for the Nexus elements. Going back to Chevron, because the Ninth Circuit read these statutory provisions as unambiguous, as just plain language, they did not need to go beyond step one of the Chevron analysis, right, which is step one, is the statute ambiguous? And then step two, is the agency's interpretation of this ambiguous statute reasonable? They found that the statutory provisions were not ambiguous, and so they did not need to defer to the agency's interpretation in matter of CTL. So in the Ninth Circuit, different standards for asylum and withholding on the Nexus piece. And then a few years later, the Sixth Circuit in Guzman Vasquez came to the same conclusion, and they explicitly relied on and adopted the reasoning from the Ninth Circuit's decision on those 2 points about the legislative history and the plain language of the statutes. There was also a small twist where the government brought forth a very technical argument, but a different one that had not been presented in the Ninth Circuit case, where they said essentially that well, Congress made changes and included this one central reason standard, this one central reason language, because the asylum statute is tied to the refugee definition, right? Technically, to win asylum, the sort of underlying requirements flow from the refugee definition, going back to the Refugee Act. And the withholding statute, according to the government's argument, doesn't really rely on this refugee definition in the same way. So that's why, even though there's different language, the Nexus standard should be the same. And the Sixth Circuit rejected this argument because, again, looking at the legislative history, in the Real ID Act, Congress did make changes to the withholding statute in provisions that dealt with like corroboration, that actually did reference the refugee definition. And so the argument kind of fell apart at that point. So in conclusion, again, in the Sixth Circuit, all of the court's decision means that the one central reason Nexus standard for asylum is different and is understood to be a more difficult standard to meet than the A reason Nexus standard for withholding. Now we'll move on to some of the other circuits that have considered this issue directly.
Awesome, thanks, Evan. We got a question in the chat. I think it's a good moment to just like pause a little bit, make sure everybody's on the same page. So someone's asking if we could go over again why the Ninth Circuit declined to follow CTL. So I'll go back to that slide. Happy to do that. Maybe just like high level, what the big picture reason was.
Sure. Yeah. Thanks for that question. So yeah, because in CTL, the BIA had one of its reasons for applying the same standard was this idea of like harmonious statutory framework, and that in their opinion, Congress wanted the same standard to apply to withholding and asylum. But then the Ninth Circuit actually, on its reading of the legislative history, they saw that in the Real ID Act, Congress made various changes to the asylum statute and the withholding statute. Again, some of the other provisions that are mirrored are about like corroborating evidence and things like that. But one change that Congress could have made but did not make was introducing the one central reason standard to both the asylum statute and the withholding statute. And because Congress left the withholding statute as is with just the A reason language, the Ninth Circuit understood that legislative history to support the conclusion that Congress actually wanted different Nexus standards in these two arenas, in asylum and withholding.
Awesome, thanks, Owen. We're gonna go over some practice pointers at the end, but like big picture, today's training is all about how we want to be arguing that a lower standard applies when we have withholding cases to benefit our clients more, so they don't have to prove up that as much. I'm curious, let's just get a sense of the room. Has anybody made this argument before? I know like some of us never heard about this argument before, Care Coalition. So we're not even sure how prevalent people, how much people are making these arguments. So if you have argued this before, put a 1 in the chat so we can get a sense. And if anybody wants to like just quickly share about what that was like making the argument, if the judge laughed in their face, if anyone's been able to win this argument, we'd love to hear. Feel free to come off mute. Ben's got a 1. Thank you, Ben. That's surprising. Anybody else? Nudge says made it numerous times in petitions for review to the Fifth Circuit with no success. That makes sense. And if no one else has made this argument, that's okay. We do want to hear if you have, but hopefully you'll be learning this new tool from today that you can try out, and know that there are some circuits that have been on our side, like the 9th and the 6th so far that we've started talking about. With that being said, Lori Rosenberg's got a 1. Awesome. Back to the Sixth Circuit decision. I know when we were preparing for this training, we all sat here for a minute and we're like, did the government really argue that? Like, what? Because the Refugee Convention from international law is where US asylum law comes from, and that does not distinguish between asylum and withholding. Withholding is a very US law kind of thing. And so to argue that it's like not connected to asylum is pretty crazy. We were pretty surprised by that, but thankfully the Sixth Circuit saw past the BS in that argument. Thanks, Ben, for sharing a footnote there from a Fourth Circuit case. Ben, do you want to come off mute for a sec if you're able to and share about that case?
Sure. Hi, everyone.
Hey.
Yeah, I raised this argument to the Fourth Circuit in a case in 2018. It ended up in this decision, Hercules Torres versus Whitaker. The court didn't reach it because it found that the petitioner wouldn't have prevailed even if the standard was a reason. But in this footnote 3, the language seemingly agrees with the argument. But it's an unpublished decision, so it's not binding at the end of the day. But that is something to cite in addition to the other circuits that have adopted the argument.
Yeah. Thanks for sharing that. That's great to know. It is open in the Fourth Circuit, right. So people can use this case. Thank you for bringing that to our attention.
Right. The problem is that people don't make or preserve the argument before.
Exactly.
Right. So,
which is why we're here today.
Right. You don't so have to make the argument in front of the IJ because there's already binding board precedent in matter of CTL. But if you're at the board, you have to argue that matter of CTL was wrongly decided.
Yep. Thanks, Ben. Appreciate you sharing your expertise with us. And on to the bad stuff, the circuits that have not gone our way.
Okay, so just as there were circuits that we think made the right decision, there were also some that we think landed on the wrong side of this argument. And the first one is the Second Circuit. And so this, I'm going to very confidently mispronounce this name, in Kitizaka v. Garland. So this was just a few years ago. The Second Circuit actually addressed this issue. They came out a little differently. Unlike the Ninth Circuit and Sixth Circuit, they held that the statute was ambiguous on its face. So Chevron step 1, and then moving on to Chevron step 2, afforded Chevron deference to the BIA's interpretation, like that we already discussed in matter of CTL, and therefore ended up adopting that reasoning, holding that they are the same. One central reason kind of applies to both. They did not 100% go with the government's argument. They also pushed back a bit. The government tried that pretty audacious refugee argument, saying that only asylum is bound to the refugee definition. They tried that again in the Second Circuit, and the Second Circuit also did not go for it. So in that sense, there is some good language in this decision shooting down that idea. But the Second Circuit did find there was enough ambiguity to move it to Chevron step 2, because applying the same motive, kind of adopting some of that CTL language about harmony and symmetry, that made sense to the Second Circuit. And they just found that because there was some ambiguity and differences of opinion across circuits, they found that they moved on to Chevron step 2, and therefore found the BIA's interpretation reasonable and adopted the same standard. So that is the circuit that has definitively spoken on this and landed on the negative side. Also worth noting that this case, like the Sixth Circuit case that Evan talked about, was regarding a petitioner who had applied for both asylum and withholding. The Ninth Circuit's case was a client or a petitioner in that case who was only eligible for withholding because he had a reinstated removal order from the past. And so that is why these arguments are so important, because not all of our clients are going to be eligible for both or able to meet the higher standard for Nexus for asylum. And we want to be leaving plenty of room for them to fall back on withholding if need be. So that was the Second Circuit. There were two more who have somewhat spoken about this. The Third Circuit in Gonzalez Posadas also found that they were going to apply the same standard to both asylum and withholding. Officially, the issue was not in front of the court. Neither of the petitioners really raised it. It was not a question the court was deciding. But in a footnote, they did drop some thoughts on the situation. It's in footnote 6, if anyone wants to go reading for it later. They didn't engage in any substantive analysis themselves about the legislative history, for example. But as you can see on the screen, they ended up saying that they thought the reasoning from CTL was sound and adopted that as well. So in the Third Circuit, this is the modus operandi of the court. And finally, the Fifth Circuit, which I know was mentioned in the chat a few minutes ago, they also do not see a difference between the two. This is a bit of a story of compounding errors in this circuit. In this case on the screen, Vasquez Guerra, the court rejected the petitioner's argument trying to argue for a lower standard based on past precedent, though, not based on any real statutory interpretation or reliance on legislative history. Instead, they denied the lower nexus standard for withholding on the case Revencu v. Sessions, in which case the petitioner hadn't even asked the court to address this issue. And funnily enough, the court there misquoted the law. They quoted the standard for asylum and then said it was with that one central reason language and said it was the standard for withholding as well. So unfortunately, in the Fifth Circuit, the precedent now does not see a difference between the standards for the nexus standards for withholding and asylum, but not because of any real stance on statutory interpretation or legislative history, but just sort of practice and past precedent.
And so we've termed the gray stuff, the remaining circuits outside of the ones that we've just discussed, where this question about is there a different nexus standard for withholding versus asylum is still an open question. And we've got the 1st, 4th, 7th, 8th, 10th, and 11th, where in some of these circuits they have considered the issue, but declined to address it head on because maybe there were other dispositive issues or dispositive rulings. Or in some cases, the petitioner maybe tried to raise it for the first time before the circuit court, and that was too late, having not raised it before the BIA, before the agency, as Ben mentioned earlier. And so because the argument was deemed waived or exhausted, the circuit was not able to rule on it directly. So this is a bit of a gray area in these circuits, which cover, I imagine, close to a majority of the states or majority of the country. And so we would, strongly encourage you to preserve these arguments before the BIA, at least. I think it can't hurt to, have the issue in front of the IJ as well, although, of course, the IJ will be bound to follow matter of CTL, but for sure you need to raise it before the BIA and arguing that the decision in CTL was incorrect for the reasons laid out by the 9th and the 6th Circuit. And we're going to get into more of those practical tips on the next slide as well.
And then before we go forward, we've got someone asking about if anyone knows the file, a cert petition has been filed at the Supreme Court given the circuit split.
That's a great question. I don't think that there are any currently pending cert petitions on this issue. I'm not aware of, I don't know what the history of some of these cases, like where in the 2nd, 3rd, or 5th, where it went the wrong way, if folks tried to get cert petitions there. I think that obviously there's a lot of, if there were to be a published opinion from one of the open circuits right now, there's a chance that it could go to the Supreme Court, depending on who wanted to appeal it. And of course, there's a lot of hesitancy from the immigration bar about bringing cases to this particular Supreme Court at this time. Although, given that it is really a question of statutory interpretation, and given the hostility that the court has demonstrated towards agencies in general, and some of the immigration decisions that have been positive, thinking back to like Pereira and Ms. Chavez, there's maybe a chance for success at the Supreme Court if it were in the right hands, and if the winds are blowing the right way that day.
So some practical matters. I feel like a lot of what we've covered today has been just very technical. For those of you who joined us for our roundtable last month about gang PSGs and gang-based claims for asylum particularly, that's much more anecdotal in one sense than this, a lot less based on the legislative history, which not all of us deal with every single day. So this is a pretty textual argument, and as we've discussed, it should be preserved. We do recommend, or we have often in our cases here at CARE, preserved this right from the beginning. It can be quite small, but starting to kind of lay some groundwork for a BIA appeal where you raise the fact that matter of CTL was the wrong decision. And then particularly in open circuits, we think this is particularly important because your case where you preserve it at the BIA particularly could be the case that goes up to a PFR where your circuit comes out the way we think is the right way on this, holding that there is a lower nexus standard for withholding versus removal versus asylum. So we will be sharing some template briefing to help preserve this issue, but we'll also be sharing the slides. So if your circuit has especially left this an open issue, we had some citations on there that you can pull, either where the court chose to not address it but had some helpful language, or some, hopefully if you are in the case in the 6th or 9th Circuit, you can pull from the cases we discussed today to support the argument that your client should benefit from the lower nexus standard for withholding. A point of clarity here, and something that I think might be especially helpful before the IJ, who might be less familiar with this technical argument, is being clear with what the difference is that you're arguing for. The standard of the burden of proof for withholding for the likelihood of persecution is higher. As we discussed earlier, it is a clear probability, so something over 50%. But then arguing that there's a lower standard for the nexus is a separate inquiry, and one that we're arguing for today, and we hope that you will be arguing for in your briefing and in your arguments. Something that we discussed in preparation that was Adina's very helpful insight was that as you kind of go down the chain of relief, asylum, withholding, and then CAT, the standard that you have to show of likelihood of future harm goes up. But then the nexus should kind of correspondingly go down. For CAT relief, you don't have to show any nexus at all, in fact. And for withholding is sort of kind of the middle ground, a higher showing than asylum, but you still have to show some amount of nexus. So we think that an argument being made here actually is very helpful to prevent wrongful deportations when there is a higher chance of harm, but maybe there's more mixed motives. For example, some of the cases that we highlighted today involved cases where the persecutor had some sort of financial motivation. The 9th Circuit case that Evan highlighted, the police were there for money from the petitioner, but also after he expressed a strong anti-corruption political opinion, then the harm that he has experienced got worse. So the court saw that as being, maybe a lower nexus. There was a pretty significant financial motive, so it was unclear if his political opinion was one central reason, but it was most definitely a reason for the harm that he experienced and the increase in harm, particularly that he experienced after he expressed that he was anti-corruption. And then finally, as we've already mentioned, there are a lot of open circuits on this, where this question is still at play, where wins could still be had. So we would encourage you to be preserving this argument, but also, given the fact that the court has not ruled on it, be prepared to meet the higher standard for one central reason for your clients, while arguing that they should benefit from the lower standard of a reason instead.
Awesome. Thank you so much, Amelia. Let's tease out that little bit more, the cascading thing you described, to make this more intuitive for you all to be able to argue. So you might have an ICE attorney who argues like, so why would someone who's eligible for withholding but not asylum, which has a higher standard, have an easier time proving nexus, right? Like it should be harder because it's harder to get withholding is sort of the idea. And so just drawing out that cascading thing, you really want to help them, the judge or the BIA is really what we're focusing on here. And eventually the circuit court see why it's different, right? So like asylum, it's the golden, version. Like that's what everybody wants. That's where you get the most benefits. You can become a citizen someday. So it makes sense that it's going to be a high standard to establish that you have nexus with asylum. However, as someone gets, unable to prove that they've got that nexus, so when it gets more unclear the reason why they're being targeted, but the likelihood of them actually getting killed goes up, the law shifts in that we're like, okay, we're not going to give them all these benefits. We're not going to let them become a citizen, but they can maybe apply for withholding if there's a really high chance they can prove they're going to be harmed, they're going to be persecuted or killed, right? And then with CAT, super hard to prove CAT, right? Really few benefits, mostly staying here when you get CAT. And so we just want to know, like, are you going to be tortured or killed? The reason doesn't really matter as much, right? It's just like, is it super likely? Is it more likely than not? So that's how I would sort of think about it. I hope that's helpful. If anyone else wants to give comments on that, or just kind of like practice saying it back, to cement that, you're welcome to come off mute. It's a good time for questions on some of the practical implementation of this or additional thoughts. Evan, anything you would want to add to that?
Maybe just to emphasize that this does come up in mixed motive cases, right? And there is a whole other body of case law around nexus for example, nexus based on family ties, right? And there's been a ton of litigation about that. We're here based on the Fourth Circuit, where we have very strong case law about establishing family ties as one central reason for someone's persecution. But the BIA, in matter of MRMS, has taken a more restrictive view of that nexus standard for asylum cases. But so many of the asylum and withholding cases that we work on are mixed motive cases. There's often some sort of general upheaval or overall like high level of violence and criminality that our clients are coming from. And then within that, our job is to show why was this person targeted? Yes, this gang or this cartel or this criminal organization is targeting lots of different folks, and often for their own particular reasons, for recruitment or for extortion, financial gain. But then there's something also particular about this person. Maybe it's their sexual orientation. Maybe it is their family group. Maybe it's their status as a single mother. And to show, obviously, we want to, as the practice tip here emphasizes, we need to gather as much evidence as we can to show that protected characteristic was one central reason for their persecution. But by preserving this argument that, okay, even if the BIA does not find it to be one central reason, it is undeniably a reason. It has to have been part of at least the calculus of the persecutors, especially when they use, derogatory language directed at a certain kind of person. Other sort of circumstantial evidence that shows that, yes, there was extortion going on, but they also targeted this person because of something about them that is protected, that they cannot change, their political opinion. And so that's the kind of case maybe to keep your eye out for, where there's mixed motive, and it may be hard to say that the protected status was one central reason, but it would be hard to deny, on the other hand, that the protected characteristic was at least one reason, or was a reason, to use the withholding statute's language. And so I feel like that's sort of the thrust of this argument overall, is to, expand protections for folks who are often getting their asylum cases denied, especially in hostile jurisdictions, but to try to use withholding and this slightly lower nexus standard as another kind of defense for our clients.
Thanks, Evan. And a really simple point I want to make is that nexus is where we see these cases lose. We get a lot of referrals, including from our direct services teams at Care Coalition, who are, in our opinion, some of the best travelers in the country. They're incredible. They put on really amazing cases, a lot of evidence. We often have to be like, the evidence for Nexus isn't there, and it's just something that a lot of people skip over. It's easy to with all of the different elements you have to cover in a fear-based case. And so we just want to really drive home that point that the evidence you get in the record is critical to be able to turn this into an impact case at the circuit court. It all starts at the IJ level, getting it in the record. So maybe if you guys could both share a little bit about what types of evidence is helpful, like what very precisely people need to get in the record. Is it a quote from the persecutor? Should it be in a declaration? Like, what's the best way? What are all of the ways?
Sure, I'm happy to speak to that, and Amelia, please jump in. There are a lot of different ways to show Nexus, but largely, direct evidence and circumstantial evidence. And I think that obviously direct evidence is very compelling. When the persecutor says, I am attacking you because of X, and that X is a protected ground, that's, your golden ticket. But persecutors aren't often that cooperative or that explicit with their reasoning. And so, again, other sorts of language or patterns of behavior by the persecutors that relate to the protected characteristic that you're arguing for. Again, slurs, certain kinds of language directed at certain kinds of people are often really helpful direct evidence, I would say, of a certain kind of animus or of the persecutor's motive being related to some degree to the person's, your client's protected status. And then in terms of more circumstantial evidence, you could bring in cases of folks that your client knew who were similarly situated and who also suffered similar persecution. You can support it with more broadly with country conditions evidence. I think it's great to have expert testimony if you can arrange it to speak to, well, yeah, this is how this criminal organization operates or this government operates, and this is who they target and why they target them. And that's another way to produce more evidence to support your client's Nexus, well, asylum claim or withholding claim, but on the Nexus element in particular.
I think I totally agree. I think that some of the expert opinions that we've seen that are really helpful are also the ones who can speak to how the persecutor will perceive your client's behavior. For example, we get a lot of cases that involve gang persecutors. And so sometimes it's really helpful for experts to be able to talk about how the gangs view any sort of resistance. Is that actually itself a political behavior, not just because the gang acts as a government body in its own areas of control, but are they likely to see any amount of resistance to recruitment, to extortion, to wanting to be, not wanting to be a gang girlfriend, for example, as discussed last month? Is that in and of itself quite political? And one of the other things that I think is really effective is talking about when things happened and being really clear on when there's a sort of temporal link between certain behaviors that you want to say evidenced protected ground. That, if someone converted to a new religion and then very quickly after that started experiencing a lot more harm or different harm or any harm for the first time ever, I think that's a pretty significant link. Or that Ninth Circuit case we talked about today, also talking about, okay, after he said he was anti-corruption, that is when harm escalated. There had been some before, but it changed. It became of a different nature after the protected ground was made clear to the persecutors. So I think that can be really effective as well.
Great. And so we do still have time for questions, but just to wrap things up a little bit and make a pitch also for collaborating with Care Coalition if you're interested. In terms of, especially in these open circuits, if you've got a case that you think could go to the circuit court level and could make an impact, could secure positive precedent that will affect, benefit not just your client, but all other similarly situated folks in that circuit. Keeping that long game in mind, again, from the very beginning, before the IJ, as well, before the BIA. And, it seems maybe like futile or a little paradoxical to argue to the BIA, hey, you were wrong, 14 years ago in this decision. And it's unlikely that they're going to change their mind in your particular case. But as we've mentioned, that's preserving the issue so that the circuit court can fully review that argument. So preserving this issue and some of the other ones that we'll talk about in other roundtables coming up, before the IJ and before the BIA is really essential in order to set your case up for success at the circuit court level. And we are available to mentor or talk shop on cases that may be pending before the BIA, and could go on to be an impact case at the circuit court level. Of course, there are lots of other organizations doing great impact litigation in the immigration space nationwide and in the various circuits. So developing relationships with those folks as well is highly recommended if you are thinking about a case that could go beyond the BIA to the circuit court. And then more broadly, we would just encourage everyone in the immigration defense bar to think about these recurring issues that keep coming up at the IJ or BIA level, where it just doesn't sit right with you. There's some sort of due process violation that's going on, or some misapplication of precedent, some issue that's really doesn't sit right with you, like I said, and where you think that there might be an opportunity to litigate a case beyond the BIA to the circuit court to try to get some oversight over the agency, to try to get some positive change in the law through litigation. That's not the only tool in our toolbox, but that's one of the more effective ones, we think, and it's our maybe preferred one here at the Immigration Impact Lab. So always happy to talk with folks about potential referrals, offer mentorship or co-counseling, and would love to be engaged with you all on these issues going forward.
Awesome. Thank you so much, Evan. Anybody have questions or want to share some comments about what they've learned today, what's worked in cases? In the meantime, I will put up the upcoming roundtables. We've got a bit of a quiet group this time compared to last month. People are really excited about the gang-based case PhDs last month. But okay, got a question from Yanni. I hope I'm saying your name correctly. Can you please share the cases in the inbox in the case law? So we're going to be sharing the PowerPoint and the recording after this, probably tomorrow. I'll be sending it out, so keep an eye out for that. Yeah, of course.
And just a reminder that we also will be sending out template briefing. So, trying to make it as easy as possible to preserve the issue before the agency, using briefing that, again, it's not overly long or anything. It won't take up a big portion of your brief, but just enough, a couple of paragraphs to preserve the issue before the agency.
Liv is asking for the last recording. I sent that over email too. Let me see if I can pull it up now to put in the chat while we're wrapping up. Awesome. Yeah, let me grab that. See if people want that. Also note, so our next roundtable will be June 6th on the family-based matters in matter of MRMS, family-based claims. Seeing a lot of people learning a lot. Someone said, thank you for, this was amazing. No questions, just a thank you, Salvi, for a great webinar. Awesome. So let me grab that link. We'll stay on for a couple more minutes. in case people do have questions coming up, and let me pull that link. Anything else that either of you want to add or like grab that?
I think one of the things that I was thinking about a lot while we were preparing for this was that I wish I had been preserving this argument earlier. Before CARE, I did more non-detained stuff. And so we had fewer clients that were really arguing for withholding, but there were some cases where I think this could have been the deciding factor. And I didn't even know it was something really to be arguing. So I hope that this will be something people can take forward and carry in their cases. And maybe their judges will be more receptive to this idea than others.
And I got the link for last month's. It's in the chat. That was on gang-based PSGs. Awesome. Well, I think that we've got everyone covered. Hopefully, if you have questions that come up as you're processing, feel free to reach out. Do keep in mind that these are the first Thursday of every month, except for July, because that's July 4th. So July will be an off month, and I'll send reminders about that. It'll be July 11th instead. Well, thank you to Amelia and Evan for doing an amazing job enlightening us on this issue. I know I learned a lot, and I hope that everybody has a great rest of your day. Really appreciate you making the time to be here. Thanks, everyone.